Good evening. I'm Ken Leon-Guerrero, a community advocate, and today we are talking about the consent of the governed. Thank you for joining me today. It is 6 o'clock and I am broadcasting live from the conference room of Megabyte Computers here in Tamuning. This is the 7th of 10 presentations I will be doing for the public on the voter initiative process. And as I said, today we're going to talk about the consent of the governed, because in the Declaration of Independence it says, governments are instituted among men deriving their just powers from the consent of the governed. That's us. When we vote politicians into office, we are giving them the power and authority to spend money and enact laws in our name. But they're not doing a very good job about it, because when we look back at 2019, government of Guam was already in trouble with many of the special revenue funds not meeting budget targets. So in other words, financially, government of Guam was going over the cliff, much in the same way as Puerto Rico did in 2016. We all know how that ended up, with Puerto Rico going to Washington, D.C. and filing for bankruptcy protection. In response to that situation, the shortfalls in the government operations, the legislature passed a temporary tax. A temporary tax. It was going to be a 5%, an increase in the business privilege tax to 5%, and it was only going to last for 8 months to offset the shortfall of the governor, the budget caused by Trump's bill that cut government revenues by about $60 million. But somewhere along the way, politicians got greedy, and without asking for our support, as required by Public Law 24222, which would require the government to take an increase in tax to the voters, they didn't. They just simply put a little clause in there, said that this is not subject to the voter approval by voters. And with that simple sentence, they eliminated a protection that was put in place by the 24th legislature to protect the people of Guam from excessive taxation. But even in spite of the tax increase, government of Guam was still in trouble, and the only saving grace for government of Guam was COVID. The arrival of COVID on our island brought billions of dollars of federal funds, grants, and support that offset the losses suffered by our economy when the tourism industry collapsed. But this is not sustainable. And even though it's not sustainable, the government still is maintaining that 5% business privilege tax, and the governor wants to keep it forever. But the problem with this increase in business privilege tax is it increases the cost of living. So in addition to the cost of living increases we were suffering before COVID, after COVID, we are seeing dramatic increases in the cost of living. And as the prices of everything go up, that business privilege tax goes up right along with it, making it harder for the tens of thousands of people who are still out of work, or if they are at work, not back at full hours, to continue to support their families. But that's not the only way the politicians have been helping themselves to our pockets. For the past decades, past 15 years that I've been back on island, I have been waging war against politicians as a community advocate, fighting against all kinds of pork barrel projects and corruption, as we saw with Guam YTK and the Simon Sanchez Okay, hold on here. There we go. Remember Simon Sanchez? The low bidder was somewhere around 75 million. The government of Guam awarded the contract to a relative of the governor who had a mixed martial arts fighting firm. And instead of paying somewhere around 70 to 75 million dollars, they were talking about running $160 million under the radar through an IDIQ contract, which would not have any oversight. So that is just one of many examples that I have run into over the past 15 years where politicians reach into our pockets to take our money and make it their money. We also saw the same thing happening with Manhita Farms. Here, government agencies violated public laws, policies, and procedures and transferred 50 acres of prime real estate from the public trust into private hands. And they were in the process of trying to make it very lucrative for the private entity to subdivide and sublease the property. Just imagine how many millions of dollars they would have made subdividing and subleasing 50 acres of property just outside of Anderson Main Gate and Camp Smith Main Gate. The fact that we as citizens were able to stop that bill in the legislature shows how strong we can be when we raise our voices and exercise our rights as citizens and stop politicians from reaching into our pockets for themselves and their supporters. And I'm sure we all know about Guam YTK, where a company that didn't do anything it contracted to do, didn't pay any of the rents it was obligated to rent, certainly never hired anybody, and never paid any taxes or gross receipts tax. And yet a trio of attorneys, politically well-connected insiders, I'm sure, all decided that the taxpayers of Guam owed Guam YTK nearly $15 million. In fact, the Guam YTK owners, who are relatives of former Governor Calvo, even got liens on the bank accounts at the Port Authority of Guam, which really concerned me because the port had just recently floated a $70 million bond, and it looked to me like they were going to be able to get their hands on the money meant for port improvements. But the Supreme Court of Guam entered into the fray, and it didn't get any help whatsoever from Governor Calvo. He stood idly by and watched as his relatives tried to stick their hands in the taxpayers' pockets and help themselves to millions of dollars. If we look at the past 10 years, the economy of Guam has stayed about the same, but the cost of government has more than doubled. 10 years ago, cost of government was around $500 million. Now the governors are pushing billion-dollar budgets. And way too much of that money is getting moved out of the government into private hands. I talked in the earlier presentations about how the landowners under Lejean bought their land for a couple $100,000. The federal receiver came in and appraised it and paid them almost $4 million. And then after the Calvo administration came into power, they turned around and had solid waste. We reappraised the property and give the property owners $31 million more. That's $31 million that didn't go to fixing our school systems, didn't go to fixing our roads, didn't go to buying new police cars or hiring new police cars, or a pet peeve of mine, dramatically increasing the number of drug detection dogs we have on this island, which is a shame because over the past 13 years, the flow of meth has continued to go up. It's gotten to the point now where just about every family on this island is being ravaged by meth in one form or another, either as users or as victims or as crime victims. And yet our politicians still can't seem to find the money to go ahead and do that, to buy drug detection dogs. but they're willing to set aside $1 million for the Pacific Islands Development Bank. They're willing to set aside $2 million to justify another pay raise for government of Guam employees, but they won't do anything to make the people of Guam safer. Remember that when you go into the voting booth. Ask yourselves, what have the incumbent senators done to make us safer? And the answer is nothing. In fact, things are about to get worse because one of the flagships of the Leon-Guerrero Tenorio administration has been the passage of Bill 30. Let me take that one out too. There we go. Bill 30 was one of the first pieces of legislation passed by the Leon-Guerrero Tenorio administration. I fought hard against that bill because this bill basically was corporate welfare. It gave Guam Regional Medical Center the power to decide who got government of Guam insurance contracts. It was illegal as hell, but the Attorney General didn't stand up for it. The Attorney General signed off on it. He did not represent the people of Guam in this manner. Take Care went to court, filed court in districts, in federal court, and won, and had the law ruled illegal. I filed lawsuit in Superior Court of Guam, and then the battle changed. Let's get me up there. Yeah, and then the battle changed. What ended up happening when I was in the Superior Court of Guam is that I ended up losing my initial case, but the logic was flawed, so I appealed it to the Supreme Court of Guam. Because what had happened is this, the Attorney General's office and the administration tried to have my lawsuit disqualified, saying I did not have standing to sue government of Guam. That as a taxpayer, I did not have the right to sue government of Guam on how they were spending tax dollars. Let's listen.
The Supreme Court is now in session. The Honorable Robert J. Torres, Associate Justice, presiding.
Would the clerk please call the case?
This is Supreme Court case number CVA 20-008, Joaquin v. Leon-Guerrero, individually and as a taxpayer, plaintiff appellant versus Government of Guam, Department of Administration, and Edward Byrne in his capacity as director, defendants appellants. Appearing for the plaintiff appellant is attorney Braddock J. Huseman. Appearing for the defendants appellees is attorney Jordan Lawrence Paloon. The panel consists of Associate Justice Robert J. Torres, Associate Justice Catherine A. Merriman, and Justice Pro Tem John A. Manglona. Attorney Huseman reserves 10 minutes.
Thank you, Madam Clerk. Attorney Huseman, you may proceed.
Good morning, Your Honors. My name is Braddock J. Huseman. I represent Mr. Leon-Guerrero. May it please the court. This case began as a simple taxpayer case and has changed into something quite different. Now it is a case that involves this court's jurisdiction, standing, and even the separation of powers. The Superior Court of Guam dismissed Mr. Leon-Guerrero's taxpayer suit because he lacked a sufficiently concrete injury to satisfy the injury requirements found in the Article 3 of the United States Constitution. The Superior Court came to that decision because of this court's opinion in what the briefing papers refer to as the airport case, In Re AB Wonpat International Airport Authority, a 2-year-old case. The Superior Court interpreted a few paragraphs of dicta within the airport case to conclude that in all cases in Guam, courts require a federal Article 3 standing analysis, particularly as it pertains to injuries. The Superior Court's interpretation, however, is incorrect. The U.S. Constitution does not mandate Article 3 requirements on the island of Guam, and neither does the Organic Act. In fact, the requirement of an Article 3 injury in fact upends literally decades of case law on Guam. Worse, the requirement of an Article 3 injury in fact in all cases as an irreducible minimum jeopardizes a host of Guam statutes, as well as this court's own original jurisdiction and several opinions rendered thereunder. Mr. Leon-Guerrero asked that this court reverse the Superior Court's decision, that it harmonize its case law, and that it remand the case to the Superior Court for further proceedings. With my time today, I'd like to discuss three main points. First, there is no irreducible minimum of a case or controversy requirement on Guam. Second is that the Superior Court erred in its interpretation of the airport case. And finally, that if the Superior Court's decision is allowed to stand, if this court does not harmonize its case law, there are catastrophic implications for jurisprudence on Guam.